Hello, my name is Yujie. I am an undergraduate at Xiamen University in China. The paper I will be presenting today is titled The Phenomenon of Difficult Enforcement in the Circuit Trial System in China from the Perspective of Power Operation. The presentation will be divided into four parts: Introduction, Current State, Causes, and Suggestions. The circuit trial is stipulated in Article 138 of the Civil Procedure Law of the People's Republic of China. It refers to a judicial practice where courts, especially grassroots courts, conduct trials directly at the location of the parties involved in order to reduce the litigation burden on the parties. Unlike the traditional perception of a trial, in the circuit trial, judges no longer sit in a courtroom. Instead, they go to rural areas to file cases, hold court sessions, mediate disputes, and conclude cases on site. The system not only embodies the concept of judicial convenience for people, but from the perspective of power operation, it is also an important means for the state power to penetrate into rural areas. Therefore, the circuit trial has been a long-standing topic of discussion. I noticed that numerous studies have briefly mentioned the challenge of enforcement difficulty in circuit trials. However, this issue is often used to justify why circuit trials tend to favor mediation and so on, rather than being thoroughly researched on itself. Therefore, this article aims to delve into the phenomenon of enforcement difficulty in rural circuit trials in China, examining its unique causes and potential solutions from the perspective of power operation. I intend to use the enforcement completion rate as a proxy, and I will compare the data from grassroots courts with the provincial average data, aiming to indirectly present the enforcement difficulties in circuit trials. Table 1 is a research at the SH People's Tribunal in Hubei Province, which point out that the issue of low enforcement completion rates in grassroots courts has persisted, and the average is about 39%. The Table 2 is another scholar's research at the T County People's Court in Jilin Province, which find that the enforcement completion rate has remained difficult to improve, tending to stay at a low level, and the average is about 13%. During the same periods, the provincial enforcement completion rates in Hubei and Jilin were respectively about 38% and 39%. Thus, it's evident that the enforcement completion rate at the grassroots judicial level is relatively lower than the provincial average, and the issue of enforcement difficulties in circuit trials remains significant. So, what are the causes of the difficulty? In this part, I will discuss this from the perspective of power operation. The premise is the phenomenon of shifting power relations in rural China, as pointed out by Su Li. Theory basis is Foucault's theory of micro power and Jesus' theory of local knowledge. The first cause is misalignment of local power relations. As Su Li said, owing to the unique regional characteristics and geographical layout of rural areas, the state power may appear relatively diminished within this specific geographic context, while the influence of individual powers may seem relatively strong. Therefore, it's difficult for relatively weaker state power to support the enforcement of judgments. It is specifically related in shortage of judicial auxiliary personnel. In some areas, the ratio of court pleas to judges is only 1 to 6. To the contrary, relatively stronger individual power is entirely sufficient to resist the weak state power. As a result, the enforcement from circuit courts requires cooperation from the individual power as the enforced party and the assistance of local power as the third party. However, since enforcement work affects the rights of enforced party, and local power often has vested interests related to the enforced party, the enforcement work of circuit courts often struggles to gain their cooperation and is difficult to carry out effectively. Another case is the lack of local knowledge among judges. In rural areas, there are numerous regional informal rules like local customs and traditions, which contrast with the formal rules represented by state laws. JIS defines those informal rules as local knowledge. Local knowledge affects and forms village standards for judging right and wrong, while formal rules sometimes will fail to meet their expectations and demands for justice. For example, in some areas, villagers see group borrowing as a justified way to fight for the honor of their village, rather than something condemnable. Therefore, when judges sentence villagers for group borrowing and require them to undergo community correction, they felt very confused and resist the enforcement. Therefore, for judges to gain the recognition and cooperation of the enforced party, it is necessary to incorporate local knowledge in the verdict. To alleviate difficult enforcement in circuit trials, the paper gives two suggestions. The first one is to strengthen state powers. Circuit courts should strengthen cooperation with local authorities and local grassroots organs to consolidate enforcement efforts. For example, circuit courts can sign a memorandum with local banks to establish a mechanism for information exchange concerning properties under enforcement. Second one is to induce individual powers to cooperations. Judges should understand local knowledge and comprehensively employ various judicial strategies. Specifically, in addition to the use of purely legal language, judges can introduce everyday power techniques and local knowledge to their decisions. Also, judges can leverage the incentive mechanisms of rural society and underlying social punishment mechanisms. That's all. Thank you.